Wednesday, November 19, 2025, AGNDD, IntelliReport topic. Nuremberg trials. Please pardon any visual and informational inaccuracies in this entirely AI-generated article-based video. Discover the brutal Nazi crimes of World War II and the international negotiations that forged the historic Nuremberg trials. In language, English. Summary of World War II Nazi crimes and path to Nuremberg trials. From 1939 to 1945, Nazi Germany invaded numerous European nations, inflicting massive brutality, including 27 million Soviet deaths, mostly civilians, and the systematic murder of millions of Jews. In 1942, occupied governments in exile demanded an international court for German crimes, but the US and UK declined, citing WBU prosecution failures. The 1943 UN War Crimes Commission debated broader mandates, including crimes against peace. The Moscow Declaration by the USSR, UK, and US vowed to pursue Nazi leaders for justice, with joint trials for high-ranking offenders. Soviet jurist Aaron Trainin pioneered crimes against peace, aggressive war, influencing Western allies. The USSR pushed for show trials to secure reparations, while the US favored legitimate proceedings to reform Germany. Britain preferred summary executions due to retroactivity concerns. Issues remained unresolved at Yalta, February 1945. Truman announced an international tribunal on May 2nd. Germany surrendered unconditionally on May 8th, ending the European War. The London Conference, the 26th of June, the 2nd of August 1945, saw representatives from France, the Soviet Union, the UK, and the US negotiate the Nuremberg trials framework, amid doubts if any trial would occur. Key offenses included crimes against peace, aggression, crimes against humanity, and war crimes. U.S. negotiator Robert H. Jackson insisted on prosecuting aggression, threatening withdrawal, though definitions were compromised to protect UN Security Council actions. War crimes covered violations of war laws, but not a government's treatment of its citizens, prompting the new Crimes Against Humanity charge, covering murder, extermination, enslavement, etc., limited to acts in aggressive wars. The US and USSR sought to avoid scrutiny of domestic policies like Jim Crow or internal repressions. The Nuremberg Charter innovated by holding individuals accountable, rejecting sovereign immunity and limiting jurisdiction to Axis, mainly German actions. Trials used modified common law, held in Nuremberg's Palace of Justice, American Zone, with Berlin as the tribunal's seat. The charter was signed on the 8th of August 1945. In early 1946, the Nuremberg trials involved about 1,000 staff from the US, UK, France, and Soviet Union, with two-thirds American, including lawyers, researchers, psychologists, translators, interpreters, and graphic designers. Each nation provided a prosecution team and 2 judges, 1 non-voting deputy. The US, led by Chief Prosecutor Robert Jackson, viewed Nazism as a German deviation, Sonderweg, and aimed for retributive and educational justice. Judges were Francis Biddle and John Parker. The British team, headed by Hartley Shawcross, assisted by David Maxwell Fyfe, had Sir Geoffrey Lawrence as nominal tribunal president, though Biddle held more sway. Francis François de Menthon resigned, replaced by Auguste Champetier de Ribes. Judges were Henri Donadieu de Vabres and Robert Falco, with staff free of Vichy ties. The Soviets appointed Roman Rudenko after reassigning Iona Nikitchenko to judge. Decisions required Moscow approval, causing delays amid language barriers. Victim representatives like Chaim Weizmann and Poland's government were denied roles, but Soviet allies, for example Poland, submitted evidence on Nazi crimes. The drafting of the Nuremberg indictment was divided among Allied delegations. The British handled aggressive war charges, while others covered crimes against humanity and war crimes on the Western France and Eastern Soviet Union fronts. The U.S. outlined the Nazi conspiracy and criminal organizations. British and American teams collaborated on conspiracy to wage aggressive war, with delegations meeting on September 17th to discuss. The conspiracy charge, not in the tribunal's charter, unified diverse accusations and defendants, targeting top Nazis, bureaucrats, propagandists for ideological justification, and industrialists for enabling war. Originating from U.S. lawyer Murray C. Bernays, it bypassed pre-1-2 crime limits but was unpopular, especially with France. Translation into English, French, Russian, and German posed challenges due to scale and interpreter shortages, particularly in the Soviet Union. Soviet official Vyshinsky demanded revisions on crimes against peace, emphasizing the German-Soviet pact. U.S. prosecutor Jackson isolated the overarching conspiracy charge. Hasty preparation caused duplications, vague language, and unclear defendant attributions. Nuremberg trials, defendants, and organizations. Key Nazis like Hitler, Himmler, and Goebbels evaded trial by suicide. Prosecutors targeted surviving leaders in politics, economy, and military, mostly surrendered to the U.S. or U.K. Unrepentant defendants included politicians: Franz von Papen, Joachim von Ribbentrop, Wilhelm Frick, Alfred Rosenberg. Economic figures: Gustav Krupp, Hjalmar Schacht, Albert Speer, Walter Funk, Fritz Sauckel. Military leaders: Hermann Göring, Wilhelm Keitel, Alfred Jodl, Erich Raeder, Karl Donitz, and others like propagandist Julius Streicher and Hans Fritzsche, Rudolf Hess, Hans Frank, Baldur von Schirach, Arthur Seyss-Inquart, and Ernst Kaltenbrunner. Observers deemed them mediocre. Of 24 indicted, Martin Bormann was tried in absentia, Krupp was too ill, and Robert Ley suicided. Defense appeals on jurisdiction failed. Lawyers represented clients and Germany. 6 organizations were prosecuted: Reich Cabinet, Nazi Party Leadership Corps, Gestapo, SA, SSSD, and Wehrmacht High Command. Goal: declare them criminal to prosecute members efficiently, implicating broader guilt without condemning all Germans. During the summer before the Nuremberg trials, national delegations gathered evidence. American and British prosecutors prioritized documentary evidence and affidavits over survivor testimony to enhance credibility, though this diminished public interest. The U.S. drew from Office of Strategic Services reports, YIVO Institute, and American Jewish Committee data, while the French used documents from the Center of Contemporary Jewish Documentation. Prosecutors called 37 witnesses against the defense's 83, plus 19 defendants testifying. They examined 110,000 German documents, entering 4,600 into evidence, alongside 30 kilometers of film and 25,000 photographs. The charter permitted any probative evidence, including depositions, making visuals like photos, charts, maps, and films crucial for credibility. However, judges required all evidence to be read aloud, causing delays. The charge's structure led to repeated readings of the same evidence, further slowing proceedings. The International Military Tribunal trial commenced on November 20, 1945, after rejecting Soviet requests for postponement. All defendants entered not guilty pleas. Prosecutor Robert Jackson emphasized the trial's broader goals, compiling irrefutable evidence of Nazi atrocities, establishing individual accountability and the crime of aggression in international law, educating Germans on their history, discrediting the traditional elite, and allowing allies to disavow appeasement policies. Jackson clarified that the U.S. did not aim to convict all Germans but neither absolved them entirely beyond the 21 defendants. Defense attorneys countered perceived notions of collective guilt, portraying it as a straw man. Historian Primel notes the conspiracy charge enabled narratives depicting Germans as initial victims of a totalitarian regime led by extremists rather than complicit actors. However, Holocaust evidence suggested widespread German awareness of the crimes during their occurrence. On November 21, U.S. Prosecutor Robert Jackson delivered a powerful opening speech at the Nuremberg trials, hailing the proceedings as a tribute to reason and emphasizing aggressive war as the core of Nazi crimes, portraying an intentional conspiracy. Well received, it set the tone for the American case, which detailed pre-war Nazi plotting but faltered on evidence for aggressions against Austria and Czechoslovakia. A shocking film on concentration camps was screened, adjourning the trial. Testimonies from Otto Ohlendorf on 80,000 murders and Erich von dem Bach-Zelewski exposed mass killings. The British, led by Hartley Shawcross on December 4th, addressed crimes against peace, grounding charges in treaties like the Kellogg-Briand Pact and Locarno Treaty, avoiding novelty claims. Their concise four-day presentation highlighted Germany's violations. Prosecutors then targeted indicted organizations and individuals, implicating the German Foreign Office, Army, and Navy in the crimes. From January 17 to February 7, 1946, the French prosecution at the Nuremberg trials presented charges, tracing Nazi ideology back to 19th century pan-Germanism and imperialism as the criminal intent behind the crimes. Unlike British and American teams, they highlighted widespread German complicity, focusing on forced labor, economic plunder, and massacres rather than aggressive war. Prosecutor Edgar Faure categorized policies like the annexation of Alsace-Lorraine as Germanization, deeming it a crime against humanity. Emphasizing victims' perspectives, they submitted post-war police reports and called 11 witnesses, including Auschwitz survivor Marie-Claude Vaillant-Couturier, who testified about atrocities. The tribunal accepted most French war crimes charges, except hostage executions. Due to the Charter's narrow definition, only the deportation of Jews from France and Western Europe was recognized as a crime against humanity under Germanization. On February 8, Soviet prosecutor Rudenko opened their case at the Nuremberg trials, detailing German crimes during the unprovoked invasion, emphasizing Allied unity while denying Nazi-Soviet parallels. Witness Friedrich Paulus, captured at Stalingrad, implicated Keitel, Jodl, and Göring in invasion plans. Prosecutors highlighted atrocities: starvation of 3 million Soviet POWs, Leningrad's siege killing hundreds of thousands, and systematic Jewish murders in Eastern Europe, often conflated with other nationalities. New evidence from state commissions and officer interrogations covered the Lidice massacre, village destructions, racist deportations for forced labor, child murders, looting, and cultural theft. They falsely blamed Germans for the Katyn massacre, actually by NKVD, though Western allies remained skeptical. Inspired by American films, Soviets presented 3 documentaries on cultural destruction, atrocities, and city ruins, including Majdanek and Auschwitz footage. Witnesses included Leningrad survivors, a peasant from a razed village, a POW doctor, and Holocaust survivors Samuel Rajman, Treblinka, and Abraham Sutskever, Vilna. The case compellingly showcased Soviet suffering and wartime contributions. From March to July 1946, the Nuremberg defense countered the prosecution by acknowledging Nazi crimes but denying individual guilt. Defendants claimed ignorance of atrocities like the final solution, blamed Hitler, mentioned 12,000 times, and absent figures like Himmler, and argued Germany's authoritarian culture absolved them. They shifted blame to social democrats, unions, and foreign powers while minimizing their roles, except Göring, who embraced his prominence. 2 quoque defenses, equating Nazi actions, for example, Nuremberg laws, camps, to Allied ones, were rejected. Judges barred most evidence of Allied misdeeds, though Donitz benefited from testimony on U.S. submarine warfare. Lawyers criticized procedures, gaining leeway for witnesses. Some exculpated defendants, others, like Auschwitz's Haas, strengthened the prosecution. Amid the Cold War, the trial implicitly condemned the Soviet Union alongside Germany. On August 31st, closing arguments in the Nuremberg trial shifted focus from aggressive war to crimes against humanity, particularly Nazi atrocities against Jews, who were highlighted as primary victims. All 8 prosecutors emphasized the Holocaust, with French and British elevating it as the central charge over aggression. Prosecutors, except the Americans, invoked the newly coined term genocide by Polish Jewish jurist Raphael Lemkin. British prosecutor Shawcross cited witness testimony on a murdered Jewish family in Dubno, Ukraine. Most defendants responded with lies and denial, disappointing judges. Albert Speer appeared apologetic but avoided personal guilt or naming non-German victims. The court recessed on September 2nd with judges secluding to finalize verdicts and sentences discussed since June. British Deputy Judge Norman Burkett drafted the verdict. All 8 judges deliberated, though deputies could not vote. The International Military Tribunal, IMT, deemed aggression the supreme international crime, encompassing all others. Judges faced challenges with the Nuremberg Charter's broad crimes but upheld them under customary law, avoiding retroactivity issues. They convicted on a narrowed conspiracy for aggressive war, dating it to the 1937 Hossbach Memorandum, not 1920. 12 of 22 defendants were guilty of crimes against peace. Most faced war crimes and crimes against humanity, with only 2 acquittals on those. 4 organizations were declared criminal: Nazi Leadership Corps, SS, Gestapo, and SD, with exclusions. SA, Reich Cabinet, and military leadership were not. Sentences: 12 to death, 10 hanged, Göring suicided, Bormann in absentia, 7 imprisoned, for example Hess, Speer, 3 acquitted, Papen, Schacht, Fritzsche, amid judicial deadlock. Soviet Judge Nikitchenko dissented, rejecting acquittals and seeking harsher penalties. The verdict exposed Wehrmacht crimes but fueled myths of its innocence. Following the International Military Tribunal, a second trial for German industrialists was abandoned due to Allied disputes. The U.S. conducted 12 military trials under Allied Control Council Law No. 10, arresting nearly 100,000 Germans and prosecuting 177 major war criminals, though many offenders escaped trial for logistical reasons. Trials targeted professionals: doctors for experiments and euthanasia, judges for judicial complicity, ministries for bureaucratic crimes. Industrialists faced charges in Flick, IG Farben, and Krupp trials for forced labor, looting, and SS funding. SS officials were tried in Pole, concentration camps, Russia, racial policies, and Einsatzgruppen, Eastern Front mass murders. Other cases included Luftwaffe's Erhard Milch for slave labor, hostages for Balkan atrocities, and High Command for aggression and looting in the USSR. Emphasizing Holocaust crimes, the trials involved 1,300 witnesses, 30,000+ documents, and vast transcripts. Of 177 defendants, 142 were convicted, with 25 death sentences tied to proximity to mass murder. Historian Kevin John Heller credits them with advancing international criminal law. Summary of Nuremberg trial's reception. The International Military Tribunal, IMT, accredited 249 journalists and issued 61,854 visitor tickets. In France, verdicts like Rudolf Hess's life sentence and organizational acquittals sparked outrage for leniency among media and resistance groups. The UK saw mixed responses, but waning interest in the prolonged trial. Germans, amid post-war hardships, followed press reports. A 1946 poll showed 78% viewed it as fair, dropping to 38% by 1950, with many later deeming it victor's justice and rejecting collective guilt. The trial's educational goals failed due to German resistance and U.S. reluctance to publish records in German amid Cold War fears. Churches and politicians pushed for amnesties. West Germany, formed in 1949, supported pardons to align with the West. U.S. releases began in 1949, with most sentences overturned by 1951. The last Einsatzgruppen convicts freed in 1958. This reinforced perceptions of illegitimacy. IMT prisoners needed Soviet approval. Albert Speer failed early release, and Rudolf Hess died in prison in 1987. By the late 1950s, West German views shifted with greater openness and domestic Nazi trials. The Nuremberg trials via the International Military Tribunal, IMT, pioneered international criminal law, though reception shifted from initial criticism to greater positivity. Key critiques include selective prosecution of Axis powers, Allied hypocrisy, for example, German-Soviet pact expulsions, and retroactive charges like crimes against peace. Novel elements, Crimes against humanity, conspiracy, and individual accountability were less contested despite historical distortions. The Tokyo trial echoed Nuremberg's framework to bolster its legacy. In 1946, the UN affirmed Nuremberg principles. The 1950 International Law Commission codified them, influencing the 1948 Genocide Convention, limited by Cold War. The 1990s revived the field with ICTY and ICTR tribunals, culminating in the 2002 ICC. Innovations included simultaneous interpretation, advancing translation tech. The Palace of Justice now hosts a museum, 13,138 visitors in 2005. While the trials inspire extensive scholarship, books and films like Judgment at Nuremberg, 1961, and The Memory of Justice, 1976. The Nuremberg trials marked a pivotal step in international justice, holding Nazi leaders accountable and setting precedents for future war crimes tribunals.
Thank you for watching this AGNDD IntelliReport, dear viewers. Please like, subscribe, and click the bell button to get notified during new uploads. And make sure to tune in next time. Stay safe and healthy. Cheers!